All right, let's get right into it. You know that feeling when you're part of a group, you've got skin in the game, but you have absolutely zero say in what happens? Well, that's exactly the frustrating spot that so many minority shareholders find themselves in. You own a piece of the company, but when things start going sideways, you can feel, well, completely powerless.
So, let's put the problem front and center. Picture this. You've put your money, maybe even years of your life, into a company. But what happens when the very people at the top, the directors, the majority owners, start making moves that are hurting the company? Or maybe even hurting you directly? Who are you supposed to turn to when the people in charge are the problem?
For a really long time, the answer to that question was basically a legal brick wall. It's called the proper claimant rule, and it comes from this ancient case back in 1843, Foss versus Harbottle. The rule itself is brutally simple. If someone harms the company, only the company itself is allowed to sue, not you, the individual shareholder. Which is kind of crazy, right? It means the victim, the company, has to be the one to sue, even if its own leaders are the ones doing the harm.
Here's a great way to think about it. Imagine a football team. The ref makes a terrible call that costs your team the game. Who gets to storm over and argue? The team captain, maybe the coach. They represent the team. That's your board of directors. An individual player, that's you, the shareholder, can't just run up to the ref and start demanding a do-over. The team has to act as a single unit.
And it gets even more locked down. A later case really hammered this home with two main points. One, the company sues for wrongs done to the company. We've got that. But two, and this is the real kicker, the court said they won't interfere with a company's internal business if the majority of shareholders could technically vote to approve it anyway. So if the majority's on board, you're pretty much out of luck.
And that right there leads us to the huge, obvious flaw in this whole setup. What happens if the team captain is the one who's deliberately fouling his own players or throwing the game for his own benefit? If the only person who's allowed to complain is the one causing the problem in the first place, the entire system just falls apart. This is the exact puzzle the law had to figure out how to solve.
So how did the law get past that brick wall? Well, it was a slow burn. It all started way back in 1843 with that super strict rule. Over the next century, courts started carving out these tiny, really hard-to-prove exceptions for something called fraud on the minority. But the real game changer, the thing that changed everything, didn't come along until the Companies Act of 2006. That's when minority shareholders finally got a modern, clear set of tools.
Okay, so here's the first major tool in that new toolkit. It's called the statutory derivative claim. Now, the name sounds a bit technical, I know, but the idea behind it is incredibly powerful. It literally lets a shareholder step into the company's shoes and file a lawsuit on the company's behalf. You're not suing for your own pocket. You're suing for the good of the whole company because the people in charge refuse to.
And let me tell you, the difference this made was like night and day. Before 2006, you had to navigate these vague old court cases, you had to prove this really high bar of fraud and show the bad guys were in total control. It was almost impossible. Now, it's based on a clear statute. You just need to show a director breached their duty, which could even be something like basic negligence. It's just so much more accessible for a regular shareholder. Now, it's not a total free-for-all. You can't just start suing left and right. You need to get the court's permission first. And it's a two-stage process. First up, you file a paper application to show that, on the face of it, you have a solid case, something that's actually worth the court's time. If you clear that hurdle, you move on to a full hearing where the company gets to argue its side, and a judge makes the final call on whether to give you the green light. Okay, so the derivative claim is all about protecting the company itself. But what if the company's finances are fine, but the way it's being run is making your life miserable? What if you're the one being frozen out? Your rights are being ignored, and you are the direct victim of what's happening. What then?
Well, that brings us to your second, and honestly often your most powerful tool, the unfair prejudice claim. This one is your personal weapon. It's designed specifically for those situations where the company's affairs are being managed in a way that is unfairly damaging to your interests as a shareholder.
So what does unfair actually mean in this context? It's not just about somebody breaking a specific law. I absolutely love this definition that came from a committee way back in 1962. They said it's a departure from fair dealing or a violation of fair play. It's all about the basic sense of fairness and the legitimate expectations you had when you came on board, especially in smaller companies that are built on trust.
And this isn't just theory, right? We're talking about classic, real-world stuff. Things like getting pushed out of management when you were promised a role from the start, or seeing the directors pay themselves gigantic salaries while the company struggles. even watching them divert juicy business opportunities to another company they own on the side. All of that could be unfair prejudice.
So, if you go to court and you win, what's the end goal? Usually, it's not about taking over the company. It's about getting a clean break. And that's why the #1 remedy, by a long shot, is a buyout. A court will order the majority shareholders, the ones causing all the trouble, to buy your shares from you at a fair, independently assessed value. It's a practical way for you to get your investment out and just move on.
So, at the end of the day, it all comes down to picking the right tool from the toolkit. And to do that, you really only need to ask one simple question. Who was wronged? If the company is the main victim, you reach for the derivative claim, and any money recovered goes back into the company's bank account. But if you are the victim, you use the unfair prejudice claim, and the remedy, like that buyout, goes straight to you. Knowing that simple difference is absolutely everything.
Because ultimately, real power inside a company isn't just about who owns the most shares. It's about understanding the rules of the game that are there to protect everyone, even the people who don't have a controlling vote. These tools exist to level the playing field. So now that you know they exist, it really makes you think, doesn't it? What would you do?